Hello, everyone. Happy Tuesday. You're at America, some assembly required. Anna and I are going to be discussing today, we're diving into justices and the role of justices and the duties of justices. And so I ask that you keep your questions to the topic here in the Jural Assembly and to the justices. And with that, I'm going to bring Anna onto stage. Hello, Anna. How are you?
I am just fine. I hope that everybody is feeling good this morning and we're ready to roll.
Doing great. So I've been sitting here rubbing my hands together waiting for you. I'm just teasing.
Well, I missed last week, so,
I know. Well, I'm glad to see you're back up and feeling well. You look good. Your color's good.
Well, 2 sick days in 5 years isn't too bad.
Not bad. Not bad at all. So last week what we did was I took a lot of questions on the prior jural process. In fact, it was 2.5 hours of questions that we took last week. So it was really, I think it was really great. There was a lot of good questions. And so, anybody that's out there, I would advise you to go take a look at last week's podcast because there were a lot of just really good basic questions that we answered about jural and, just the processes. So today what I've got is we plan to move on with our justice in our kind of our course here that we've been putting on. And of course, justice of the peace being on the county. But a lot of people, I think it's really important that we get down to what are we looking for in a justice? What do they need? What do they need to demonstrate or know when they decide to step up and be elected into being justice? And then kind of how do the justices operate in our court? I've got a little bit of an idea in terms of I looked up justice responsibilities on sort of from the de facto side of common law. Not real close to what we do, but I like to compare and contrast those later when we get to it, so that everybody kind of understands the difference between our type of justice and their type of justice. Okay.
Well, they're not typically, let me put it this way, they're not supposed to have justices.
No, they're not.
They're supposed to have judges.
Right.
Which is a different kind of animal. Just as there's a difference between a counselor of law and an attorney, okay? And these are jurisdictional differences. A lot of people call me Judge Anna, but I'm not a judge. I'm a justice. And I understand that this is a common assumption that the two things are the same. I understand that it's a common assumption that a judge means a justice or vice versa, but they don't really. The difference is rooted in the Bible, where you have two different kinds of authorities. You have the authority of God and you have the authority of man. And this split happened when the Israelites asked for a king to be set over them. And I believe that's in the book of Samuel. You can just, look it up, where they came to the prophet and they said, we want a king set over us, like our Canaanite neighbors have a king set over them, so that we have somebody that we can rely upon to make very prompt and obvious judgments for us, Okay, so Samuel goes to God and tells him they want a king set over them like the Canaanites have. And God kind of mocked them and said, okay, you want a king? Here's Saul. Have fun. So when man rejected God as their king, a whole bunch of things happened. One of which was the development of legal systems that are, the rules of men, as opposed to lawful systems, which are derived from God's law, God's system of doing things, universal law, natural law. So you've got two systems here. You've got a system that is based on our understanding of nature and of nature's God, as the founders put it. And we've got the law of men, which includes all of the various things that mankind has set in place that are not derived from any natural law. So, two systems running in tandem. And by far the system that has the greatest authority is the system of natural law. But you don't see that because the system of man-made law has taken such a precedence. It's become so all-encompassing that all you ever hear or see if in the course of normal life is this other kind of law that was created by mankind, and all you ever see are the people that administer that kind of law, who are known as judges. But the ones who are administering God's law, the law of nature, of the Creator, they're called justices, and they're over here on this side. Okay?
Yes, exactly. Well, I was going to bring up the fact that that's in 1 Samuel, I think it's chapter 8, where that occurs. So if anybody's really interested in the reference.
I think that is actually the crux of the whole matter. I think that is 100% the crux of what we've all gone through over the past several thousand years. Right there. It's you have to make a decision in your own life whether you're going to be ruled by God or you're going to be ruled by man. And, if we could just settle this one thing, we would be an infinity beyond where we are now. But this has been an open argument, an open issue since the days of Samuel the prophet. So will you be ruled by man or will you be ruled by God? And if you're ruled by man, then you're ruled by fools.
Right. Right. Exactly. Why would we choose man over the ultimate creator? I mean, that makes no sense. Makes no sense.
Well, it's convenient to have somebody tell you what to do. And this is the nanny state mentality. Now that all this crap has come out about, the mismanagement of the money and the waste and the abuse and the fraud and all the rest of it, it's finally come out and people are just left stunned, And, we're discussing it in terms of the bankruptcy. Well, we know about the bankruptcy because we've been paying attention. But we're having a lot of people that are responding like 4-year-olds when the nanny left the room. It's like, oh, I'm so dependent on the nanny and the nanny left. Oh, what are we going to do? All these federal workers are being jettisoned and all these federal programs are being quit. And they're just going to have to live without the nanny. They don't know what to do. They think the sky is falling. And actually, they're just returning to their own natural condition in a state and being forced to pick up and do their own work, make their own decisions.
We were always meant to have, that's why we had 18 enumerated powers in outlined in the Constitution. We were always meant to take care of the rest of the things on the states, and mostly by private resources that way. We were meant to set up our own small businesses. Everybody's always heard the small businesses are the engine of the United States. Well, they are. And they're the ones that are supposed to be out there providing the services, not the behemoths.
Right. Exactly. And on top of that, we have a situation where the justice system has been, how can I put this, substituted. We're supposed to have one kind of law governing the people of this country, and instead all of the people have been redefined as corporate franchises, and everything is being operated under this foreign form of law. We're supposed to have justice, and that justice is supposed to be applied by what? Justices. But instead, we have man-made codes, rules, regulations, things that are administrative in nature, okay? We've got all of these things over here that are being misapplied to average people. And they're really meant to be applied to corporations and officials that work for corporations.
Right.
Okay?
I call it the employee handbook.
Right. It's if you're not a federal or franchise employee, then all of this kind of law, statutes, codes, regulations, ordinances, mandates, all that stuff applies to them. It does not apply to us. It was never meant to apply to the living man or woman. So now that we're aware of that fact, the question is how to get back to where we belong. How do we invoke our law? And how do we set up our courts, which are over here on the justice side?
To deliver that true justice. That's why most of us are here, right? We've recognized the fraud, we've recognized the injustice of their system, and that is the big reason most of us have changed our political status to come into this, basically just system of government, and our courts are the main watchdogs of that freedom and of that justice.
Right. And you'll notice that we do not judge people in terms of, issuing a moral judgment, right? We're not sitting in judgment of individuals. We are sitting in judgment of the law and the facts. All right? So it's not like we are condemning Joe Blow, but we are looking at the actual facts, and we are condemning the action, and we're looking at the actual law, and we're determining whether the law is fair.
Right, exactly. So what do we, when we're looking from our assemblies and we're trying to find someone who would make a good justice, how would you describe that man or woman?
Well, the very, very most important characteristic of a good justice is that they be logical and fair. You cannot be a good justice if you are prone to prejudice or lack mental acuity or lack a fine sense of logic. Now, in our system, the primary role of the justice is to pronounce the sentence of the jury and to set up the court in such a way that decorum is maintained and evidence is preserved and evidence is properly adjudged, whether it's admissible or not, which basically comes down to is the evidence of a good, solid provenance? Is it hearsay? If so, it cannot be admitted as evidence. And certain basic rules that apply to evidence to make sure that the evidence that the jury is presented with is truly admissible and accessible and solid, okay? So, but basically, the judge is just concerned with getting the facts properly before the jury.
Right.
And then the jury decides. The jury examines both the facts of the case and the law being applied to the case. And it's equally important when they say the facts and the law. Okay, so the facts may be that on April 17th, 1999, Joe Zebel walked out his front door and knocked over the mailman by mistake. Okay. The mailman fell on the sidewalk, hit his head, and has been in a coma ever since. Okay. Those may be the facts. Then we look at the law. Well, the law may say that, causing permanent disability is to be considered a form of manslaughter. Well, then we look at that and we ask ourselves, well, is it really manslaughter or is it a form of accidental injury? See, the jury gets to consider both the facts and the law. Does this law apply in this way? Is the law properly defined to fit these facts?
Okay.
So we get to look at those issues as a jury, make a determination, then the jury foreman delivers the decisions of the jury in open court, reads them aloud, and the judge then takes that determination by the jury and pronounces the final sentence.
Right.
He acts as the speaker of the jury.
So where does the justice then have any kind of interface with the jury at any time other than in the courtroom itself or when the jury speaks to him or her?
They're really not supposed to. The justice is not practicing law in our case. They're not. They're like a referee. The justice is like a referee. The justice is sitting there making sure that, if a jury is impaneled, that they stay impaneled. If a jury is asking for certain records or information, that is provided to them. The justice in our system is acting much more as an administrator of the court and of the process of the court, and isn't really involved in making the decisions that the court is enforcing. The decisions are being made by a jury of 12 peers. Now, what we mean by peers is also somewhat different. When we're talking about peers, we're talking about men and women who have claimed back their status as living men and women and who are claiming their birthright political status and are operating under American common law And so they're in a different peer group than people who are operating as British territorial corporation officers. Okay? These are two different peer groups. And so when it says you have the right to a trial by jury of your peers, it means that you have a peer group and you have to be you have to face the trial for within your peer group. And this comes up all the time when we have people from our assemblies that are being asked to serve as jurors over here in the other system. They can't actually operate as peers for British territorial persons because they're not British territorial persons. They're American people, you see. So this causes a situation where we can't act as peers in their courts, and they can't act as peers in our courts.
Right. Right.
Different jurisdictions, different forms of law.
Okay, I'm gonna add up here since we're diving in at this. So I asked, I went out and did a little research and asked, justices and what are the duties of a justice in common law courts. And so as I read through it, the red is where I would say, no, that's not really doesn't apply to us. So adjudication. Justices preside over, of course, legal, not it would be lawful disputes, and ensure that trials are conducted fairly. They listen to the arguments presented by both parties. But that's sort of where their influence ends, is it not? Because while they do examine the evidence to make sure it's appropriate, but they do not make rulings based on the facts or the case of the law. The jury does that, just as you spoke.
Yeah, well, they do more than examine the evidence. They make rulings about the evidence. If the evidence is hearsay, for example, it's the duty of the justice to nix it and say, no, we can't accept that because that was third party, so-and-so heard from so-and-so, then so-and-so heard from so-and-so, and we can't accept that as evidence. Okay, so they do make rulings about evidence in our courts. They don't make rulings. Rulings, even the word rule, ruling, right? We don't have a rules-based system. When you're dealing with American common law, you're dealing with prior court decisions that may or may not apply. And so part of examining the law is that when a controversy arises and you have people bringing forward something in dispute, you look at similar cases that have come about in the past, and you try to make a determination based on those former cases. And if you can't, well, then you have to set a new case precedent for a new situation, right?
Right.
But this is being done by a jury of your peers. It's not being done by the judge.
Right.
The judge can offer information. The justice can offer information. They can point out things in the law that the jury may not observe just because they're not learned in the law, but they don't have a function of practicing law from the bench. They're not there to do this. So again, they're more like a referee, saying, okay, this is in bounds, that's out of bounds, this is solid evidence that can be considered, this is not solid evidence, it can't be considered. We have a proper chain of provenance and custody of this evidence. We don't have a proper chain of custody and provenance of this evidence. Therefore, We can present this evidence, but with the caveat that we don't have the provenance of it. These are things that the justice can do to set things up as cleanly and clearly as they possibly can for the jury to consider all the facts and to know the law and to consider the law. Okay, the judge or the justice in this case is supposed to be there as a resource for the jury. Okay, they're not supposed to be doing.
Oops. And it just froze. Or I froze. Okay. So one of the reasons that I bring this up to Anna while we're waiting for her to come back is that a lot of the in my speaking with a lot of the
I'm back. I don't know what happened, but we're having kind of glitchy service here today.
Okay.
One of the things we see in their courts that is really detrimental is the judge leading the juries, telling the jury that what the limits of the jury's powers are, telling the jury that they have to find in this case this way or the other. And then the jury, of course, not being legal eagles, just follow along and go with whatever the judge tells them. And that's not what a justice is supposed to do. In fact, it's improper for the judges to be doing that. But in any event, we don't want to lead the jury. We want to assist the jury. We want to be sure that the jury has all the information it needs. But it's not our job to actually judge the case. Right?
Right. Well, one of the reasons why I'm kind of setting this comparison up, Anna, is, as you know, I go to many of the state assemblies, present, and sometimes I get a few questions on Jural, and they're all trying to figure out just exactly what the job descriptions are. How do I detail this out for the justice, right? And many of them have turned sort of to some of the de facto definitions or discussions that are out there. And I want to make sure that we're pointing out as we go along the things that are not what our justice is supposed to be doing, as well as the things that they are supposed to be doing, so that we're not confusing the two systems. And it's ever important that we realize that the judges in their system do act differently. They can judge, meaning they can be the ones to make the final decision. They can throw away any advice, and that's what it is from their juries, is they can throw away that advice for the most part and come up with a different decision. Right. But in our courts, our jurors reign supreme in that aspect.
Right. I want to just point out a common problem that arises between the two court systems. When a person, meaning a corporation or a franchisee, is in a court case in one of their courts, they will often be offered a jury trial. A jury trial is not the same thing as a trial by jury. That little important word, by, has to be there, or it's not actually a trial in the sense that you think of it. A jury trial just means that a jury is summoned to provide an advisory opinion to the judge. But a trial by jury is the actual kind of trial that you associate in your mind with having 12 of your peers look at the facts and the law and render a decision about it.
Right. That's a great reminder. So let's go back to our chart that's here and talk about interpretation of law. the justices, they interpret and apply laws. Well, they don't exactly apply them. They bring them out and really make them, I don't know how to describe that. They look at what's going on, and anything that would be applicable, they would bring forward for the jury to consider, correct?
Well, in their courts, they interpret the law.
Right.
Okay. In our courts, the jury interprets and judges the law.
Right.
Okay. In their courts, they're dealing with statutes and legal ordinances and regulations and other forms of law besides any legal precedents. You see that word legal? They're not talking about lawful precedents. They're not talking about American common law. They're talking about maritime law. They're talking about admiralty law. They're talking about martial law. They're talking about commercial law, anything and everything but American common law, which the federal courts have fully admitted they don't have any form of general common law.
Right.
So
right.
what they're doing is actually interpreting statutes. They're mixing terms and calling laws. They're calling them laws when they're not laws. Okay, they're calling them laws when they're actually codes, when they're actually statutes, when they're actually regulations. So that's a semantic thing that really needs to be overcome. So what they're interpreting are all of these legislated laws. Now, what results from a legislature is actually a statute, a code, a regulation, an ordinance. It's not law. They call it law, but it's not law. So when they say their interpretation of law, they're actually talking about legislative law, quote unquote. We're not talking about legislative law. We're talking about law that has been adopted by the public, for the public, by the people, right? And that is interpreted by actual cases, by case law. The American common law is based on case law. And so, generally speaking, we have a law prohibiting murder, for example. All right? Murder falls into various categories. Did this occur with malice aforethought? Was this premeditated? Did you sit there in your living room and plan how you were going to get rid of John MacArthur Stewart? And did you then follow out on that plan and bash him over the head and take his dead body into your garden shed and saw it into pieces and, whatever, right?
Right.
Was this premeditated? Was this a crime of passion? You came home and you found your wife in bed with this guy and you just went completely berserk and you killed him. Okay, was this a crime of passion? Was this a inadvertent act of manslaughter where you didn't intend to kill anybody? You certainly hadn't premeditated it in any way, but you were driving down the road and hit a patch of ice and your car spun out and you hit a pedestrian on the sidewalk and killed him. Okay, that's an example of unpremeditated murder or what is called manslaughter, where you didn't mean to, and it wasn't something that you were directing by any purpose in any purposeful way, but it still resulted in someone dying.
Right.
So there are different shades of the whole topic of murder.
Right.
And so we are in a situation where we have to compare cases that have gone before as a first resort in making a determination. Because if other juries have already sat and considered this same exact scenario, or so close to it as to make it immaterial, that then we look at what other juries have decided in similar circumstances. We examine the case law, and we make a determination in the current case based on the reasoning and the circumstance and the law that was already looked at by other juries. And this is just a matter of common sense and trying to cut through an awful lot of rehashing of the same exact situation, the same exact kind of details, and to come to a decision faster, based on work that's already been done by others, right? This
Right.
is, traditionally, given this set of circumstances, this is our determination because, it's already been looked at in 15 other cases. And, in all of these other cases, the independent juries all came to this conclusion, therefore we come to this conclusion, because the logic and the facts and everything are there. And this is, we're basing this on past precedent, right?
That's correct.
And so then whatever happens that's, something that's totally unforeseen, something that is outside of any precedent that went before, well, then we have no precedent to consider. Mankind is endlessly creative, and circumstance is always evolving, and different things happen in different ways. And so it is entirely possible that even after 200 or 300 years of collecting case law, you'll come up with something, a case will show up that has never been properly addressed. The circumstance is different, or the essence of the circumstance surrounding it is different.
Right.
And then you're called upon to look upon it completely without precedent and to set precedent. And that's why there's this big furore about a precedent-setting case. Okay? Because in our system of law, once a jury has determined the facts and the law, there's nothing that can overturn that. We've already looked at that once or twice or 3 times, and this is the determination. So our system is considerably different than their system, because they will look at former cases, yes, but they are not really, they don't necessarily honor past precedent. They
Exactly.
don't, they can do anything without, they use past legal precedent to justify their reasoning on some occasions. Sometimes they just throw up their hands and say, well, this is what I think, and they give their opinion.
Right.
And you'll notice that it's always their opinion, because they're not basing it on facts and law, they're basing it on opinion.
Yeah, wasn't there one of their attorneys, their lawyers, that said I can convict a ham sandwich, right?
Right, because it's arbitrary. It's their opinion of the law. It's their opinion of the facts. It's their opinion of the person. That's why they use words like it's under your discretion. Okay? Our system of law does not allow discretion, and it doesn't deal in opinion. It deals in past precedent of case law. It deals in solid definitions. It deals in
facts, evidence,
and law,
and witness testimony. Those are the basic things that make it up.
right. and so we don't rely upon a judge's discretion. We don't rely upon a judge's opinion.
Mm-hmm.
The opinion of the jury is what counts in our system of law.
Correct. Okay, so so as we move forward in this sentencing in criminal cases, well, it basically says that they determine the appropriate sentences for convicted or convicted individuals. They consider the nature of the crime, the mitigating and aggravating factors, and the sentencing guidelines. Well, that actually is our jury that does that, not the justice, right?
Right. Our jury is the one that recommends the sentencing, and they are the ones that consider the facts and the law. Often, whatever mitigating or aggravating factors might enter into a case come as a judgment against the law. If the jury feels that a law is unfair, or that it fails to take in mitigating circumstances, that the jury, has a strong sense that because the law does not include these mitigating circumstances, it's unfair, they can toss out the whole law, send it back. So, whereas their courts will get into this business where the judge is sitting there and he's got a guilty a finding, and then he's kind of stroking his beard and he's looking at a statutory law, which is not a law, okay, for in our system, it's a law in their system. He finds that, well, this is a first-time offender, right? You've all heard that. Oh, well, you're a first-time offender. You have no significant prior criminal record, okay? You were drunk driving because you had just lost your father, and you were, went out on a drinking binge as part of the funeral. We'll give you a lesser sentence because of mitigating circumstances. That is common in their system, where the judge can just use his quote unquote discernment to decide whether or not you're likely to be a repeat offender, whether or not you engaged in this crime willfully. He might decide that, oh, you had an unhappy childhood, so maybe you were maybe you had an abusive parent that was sexually abusing you, and you murdered them in self-defense. All these different mitigating factors and aggravating factors can go on in one of their judges' heads, and he can render an opinion that, okay, well, you're good to go. And we're going to set aside these murder charges because you had an unhappy childhood and because you were raped repeatedly by this fiend that was your father. Okay. Mm-hmm. Our law doesn't work like that, and our justices don't work like that. Our law, the facts of the case and the law itself is considered by our jury, and whatever the jury decides becomes the law.
Yes, exactly. That's exactly it. So that's in, again, when we look at, again, this list there, it says the legal reasoning, justices write detailed opinions. Again, as you pointed out, they're just opinions. Everybody has one, right?
Right.
But in our courts, it's our jury that makes that decision. And that decision is pretty much final unless there's some major flaw, or there is new evidence that would come up to change that, and it gets retried.
Right. Our jury decisions are final. Nobody can overturn one of our jury's decisions, except another jury reconsidering the case based on new evidence. So, for example, a guy is accused of murder, and he's convicted by a jury of murder. He's never going to overcome that until and unless someone comes forward and says, hey, wait a minute, it couldn't have been him because I saw him at such and such a time and place, and that means he couldn't have possibly have murdered Joe Blow. Or someone comes forward and says, yeah, well, I know who really murdered Joe Blow. Okay? Or someone says, well, this material piece of evidence that was used to convict this man is not correct. This wasn't true. This didn't happen this way. Okay, so if you get new material evidence, you get new primary witness testimony, then you can go back and revisit a jury trial. And then you go back and you summon a new jury, you put in the new evidence, and they reconsider the whole thing. And the guy that was convicted can then be released if the new evidence is compelling.
Right.
Once in a while, rarely, you will get a mistrial in our system as well as in the legal system. You can have a mistrial in a lawful system just as well as you can a legal system. And now, what might constitute a mistrial? What if an official of the court has an undeclared conflict of interest that might have played into what evidence was presented to the jury? That's a mistrial. What if it turns out that the judge, unknown to everybody, is the cousin of the defendant, and he uses his position and his influence to, in some way, tweak the evidence or hold some of the evidence back that would serve to convict his cousin? That's a mistrial. And suddenly you have to go back and do everything all over again with a different jury and a different judge, and the whole thing gets kicked out and you start over again.
Right. So those are the things that we have to keep vigilant on so that we don't necessarily allow any kind of conflict of interest within our courts. We've gone over that in jury, what that is. And so, our juror pool has to be very vigilant about their ability to sort through those issues and make sure that doesn't enter into our courts.
Right. I mean, even things like say that there's a case brought against a local fire department for some particular mismanagement of a fire scenario. You would, if your brother was a member of that fire department, you would want to recuse yourself as a juror, because even though it isn't your spouse, it is a blood relative, or even an adopted brother. You would want to recuse yourself and say, no, I can't sit on that jury because I know so-and-so, and I would be prejudiced in his favor. Yeah.
I had a question come up about that, okay, what if it's an injury, a true harm, right?
Right.
And you're in insurance and you're on the jury pool, can you be a juror on that? As long as
Well,
it
no,
isn't your company, I would.
yeah, I mean, if okay, say that you're a State Farm agent and there's a claim against State Farm by the, the plaintiff is bringing suit against State Farm for negligence in the processing of their insurance claim. Well, obviously, if you're a State Farm agent, you're going to say, no, I can't serve on that jury.
Right? But if you're with Allstate, you might use it for good purposes. No, I'm teasing.
You would want to really seriously consider, whether that is something that could influence your
Sure.
ability to reach a fair and unprejudicial conclusion. I mean, simply being in the insurance industry could be a basis for not wanting to sit on such a case, because you already know so much about how that works and how insurance is supposed to work and everything, that you might be prejudiced in favor of the insurance company.
Right. So really, that really relies on each man and woman to identify that conflict of interest within themselves.
Yes.
But they have to also make that known in the jury pool. They may choose to have somebody a little bit different in that seat than,
Right. I have been asked to sit in juries where I'm not a member of their peerage, and so I can't sit on their jury because I'm not a peer.
Right.
I've been asked, even before I knew that, I've been asked to sit on their juries concerning things that I would have a prejudicial interest in.
Mm-hmm.
Just things that I know that would prejudice me one way or another. Like, I know that property taxes against Americans are illegal and unlawful and unfair and insupportable. And so if you put me on a jury of one of their courts, I would be saying,
from the get-go.
yeah, right. I would be prejudiced from the get-go simply because of my knowledge of the actual law versus the statutory law, and because I would be an advocate for the plaintiff in that case. And I would be stepping my foot in their cow pie.
Right.
And and so I
But
would
in our court, that might be to our advantage, right?
Yeah, right. Well, but I would be a prejudicial juror. I would already have my opinion about the basic circumstance all set in cement and ready to roll out, and I would be operating knowingly in their system. And it's not appropriate for me to act in their system when I'm claiming my birthright position and jurisdiction as a living, breathing, here I am, dear God, American. Right?
Right. Exactly.
Just
Okay.
like it's not fair for them to come over to our court and bring their prejudices with them.
Exactly. Which is, also the point with having to interview our tail. If we have to get a talesman, we have to make sure that that's done very thoroughly.
Yes.
Okay.
Exactly.
Right.
And everyone, the entire population has to become aware of all these different aspects and issues, so that people are not constantly crossing back and forth and pretending to be one thing and then another. Okay, we need to set it in our own minds which group we belong to and which court we're standing under, and make a decision and stick with that decision. I see a lot of people who want to play both sides of the fence, and that's not really possible.
No, can't serve two masters. Okay, so legal they call it legal reasoning. I should have read that.
Lawful reasoning.
Lawful reasoning. Justices don't write detailed opinions and judgments. They only speak what the jury does, and these decisions become part of a lawful precedent once the jury decides them and guides future cases. So you've said that several times in different ways.
Well, okay, justices do write detailed opinions sometimes, but those are in issues where it's about the law. Okay, it's not about an individual case, it's about the law itself. And so then you write a detailed opinion of the law. And you can write an opinion. Anybody can have an opinion. You will notice that the majority of their Supreme Court cases, now we're talking about the U.S. Supreme Court here,
Right.
okay? You'll notice that a majority of their Supreme Court cases are dealing in the opinions of the majority and the opinions of the dissenting minority. And they are going through their legal reasoning of, why this particular law or this part of the Constitution should be interpreted this way or another way, right?
Right.
So this is where you get people acting as justices, Supreme Court justices, right?
Right.
Talking about the constitutions. And what are the constitutions? Land law.
Right. There you go.
Okay. So you do have some, at the very top, you have some areas where you do have justices writing in the land law detailed opinions. But speaking, day to day, you don't have, our justices don't write detailed opinions about anything. Our justices may have an opinion as an individual, but they don't enter into the process of a court that's running under a trial by jury. So when the end line comes out of the jury has documented their reasoning. They have come to a reasoned determination, and they are the ones that write out their reasoning, and then they come forward with their determination. It's the jury actually isn't talking about legal reasoning. They're talking about their reasoning as living, breathing people. Given fact 1, given fact 2, and given fact 3, the jury hereby determines that blah, blah, blah.
Right. Okay. All right. So they have case management. They manage the flow of cases through the court system, ensuring that cases are processed efficiently and that the rights of all parties are protected.
Well, and that gets to the role of the justice as kind of an administrator of the court. We as living people have a right to a speedy trial. We can't be held up for, held in jail for a year waiting a trial, right? Mm-hmm. And so it's the business of the justice to make sure that you're getting an expeditious trial and that you are getting through this bump in your road as quickly and efficiently as possible.
Right. Okay. All right. So judicial review. Justice may have the authority to review and invalidate laws or government actions that are found to be unconstitutional.
Well, okay, now this is where you're getting into Supreme Court justice, layer justices, because they do have they do have a very few people who maintain the role of justice on the land, and that is a Supreme Court function where the Supreme Court justices do have an authority to review and invalidate laws or government actions on their side, right? On their system,
Right.
and they can declare them unconstitutional. So this is where you get into cases like we just had this past couple of years, where the Supreme Court may review things that are actually old.
Right.
You know?
Like West Virginia versus EPA.
You're right. Right. And where, Norton versus Shelby County was decided 117 years ago. And the justices reviewing this came back and reaffirmed at a higher level the determination of was it Tennessee Supreme Court case that was 117 years old. And then that was then reiterated again by another Supreme Court case this past year, the Loper Enterprises case.
Right.
Same thing, where a justice operating in terms of land law still has the ability to review and invalidate things that the regulatory and legislated law has set up that is unconstitutional.
Right. Okay. So, but really, when it comes down to invalidating or what we call nullifying laws, that's really jury responsibility, isn't it?
In our system, it is the jury's responsibility to evaluate a law and to determine whether it's, a appropriate and fair and plainly stated and valid law, or if it's just something that's unconstitutional or intrinsically unfair, or so vaguely worded that nobody can tell what it is. I mean, there are many different reasons that a jury may find that a law is insufficient or vague or improper in some way. A jury can find against the constitutionality of a law, but then it will be appealed and it will go all the way up to our Supreme Court, and our Supreme Court will levy the final determination.
Okay. All right. So, administrative duties. In addition to their courtroom responsibilities, justices often have administrative duties such as overseeing court personnel, managing budgets, and ensuring the effective operation of the court.
Well, I would say that case management is an administrative duty. I would say that disciplining court personnel is another administrative duty that both justices and judges pursue. For example, say that you've got a murder case and the prosecutor is being overzealous and trying to bring in evidence that is clearly tainted. That it would be the justice's duty to haul the prosecutor in and say, "What for? Why are you trying to bring in this tainted evidence?"
So would that be prosecutor or would that be a counselor at law who was acting on behalf of the murdered in our jurisdiction?
In our jurisdiction, we do have public defenders and we do have public prosecutors, but only for those cases where the victim of the crime is not able to speak for themselves. So obviously, if you've been murdered, you can't speak for yourself, can you?
Nope.
And so in a case like that, you do have a public prosecutor who is prosecuting in behalf of the victim.
Okay.
But even if they're, working on the side of the victim, a prosecutor can become overzealous. Say, for example, it was the friend of a friend, and this was a good person, and they were, murdered by some axe-wielding illegal alien.
Oh.
What? Number one, where's our jurisdiction? Number two, say that the axe was found 5 miles away and was completely wiped of any fingerprints, and you're still bringing forward this as evidence without any DNA or anything to connect it to the crime. Well, then the justice would be honor bound to disallow evidence that has been tainted, evidence that has been tampered with, right?
Mm-hmm.
And so, the justice has a duty to oversee, things like the chain of custody of evidence. If there's a likelihood or a possibility that's significant that evidence could have been tampered with, it's up to the justice to say yay or nay. And there are a lot of different cases. Think of all the cases that come up where, police officers are accused of wrongdoing. Sometimes they are accused of wrongdoing and they are guilty of wrongdoing. And then you are in a situation where you have a mixed jurisdiction dispute. You've got a lot of evidence that may or may not be tampered with or edited or omitted. You see, these things can get very complicated. And somebody has to act as referee. So the justice is essentially a referee and sets up the playing field to make it as flat as possible.
Mm-hmm.
So that the jury is given the reliable facts, they're given the law to examine the law, what the history of the law is, what the intent of the law was at the time it was passed, right?
Right.
And any case law that pertains to the case in front of the jury. And it's the duty of the court to prepare the playing field, so to speak, to prepare all that background and to present the evidence to the jury. And then the jury, as 12 peers who are not necessarily learned in the law, but who can think and reason for themselves, given the facts and the law, are then able to come to a determination in the individual case.
Okay. All right. Upholding the Constitution. They have a duty to uphold the principles of the Constitution and to protect the rights and liberties of individuals.
Well, they certainly do, but they don't.
I know.
In their system, it has long since been converted, where the judge's oath since 1991 has been altered by Congress so that it no longer obliges the judge in their system to make decisions agreeable to the Constitution. That part of the oath has been removed. And it's just this little tiny, it's like 4 or 5 words long, but it was removed from the oath by Congress back in 1991. And as a result, judges in their system no longer have to pay attention to constitutional issues.
Yeah, and they'll tell you that really quickly, too. They tell you, the Constitution has no place in my courtroom.
Right. Now, whether Congress had the right or ability to do that has not been challenged, but it should be challenged, and I'm sure it will be. Congress has no right to alter oaths which they themselves are subject to also.
Okay. But as far as applying to us, again, the Constitution doesn't apply to necessarily living men and women, because we are not under that Constitution. We are the ones that wrote the Constitution. We're the employer side of that contract.
Exactly. And this is something that so many Americans have difficulty with. They don't realize that the Constitution is first, last, and always a service contract. They think of it as some sort of sacred cow, some sort of almost mystical, scriptural thing. And in fact, it's just a service contract. And we are the employers receiving the services. Okay, that's our role. We're the employers receiving the services. The Constitution is the contract. And that's why our employees, our federal employees, are so completely fixated on the Constitution. That's their bread and butter. That's their rice bowl. That's their
Gravy train.
That's their gravy train. They are obligated to uphold the Constitution, because without the Constitution, they don't have a job.
That's right.
And on top of that, they don't have a right to reside here in this country. Okay, so they're very attuned to and focused on the Constitution for all those good reasons. We, however, are the ones who wrote the Constitution and adopted the Constitution as the means to define their duties and limitations under their service contract. So we don't stand under the Constitution as Americans. Our federal employees are obligated to operate under the Constitution and to respect and uphold it. But we're not living under the provisions of the Constitution. We're protected by the Constitution from offenses of our employees.
Or supposed to be.
Yes, or supposed to be. The Constitutions limit the powers and define the powers of the federal government. And they do not define the powers of our government. Our government stands under the Declaration of Independence, which is a quite different proposition. And so when you're talking about upholding the Constitution, you're talking about upholding the service agreement, that they have a service agreement that they are obligated to honor, and we have an obligation to pay them, which is what we honor.
Right.
As long as they are doing their job, then we do our job.
Okay. All right. Well, I got just a couple questions today. So actually, pretty much only one question. Do our court jurists have to be unanimous in their decisions to deliver decisions, a judgment?
Only in a capital judgment case. If it's a capital crime and you're going to take someone's life, you have to be unanimous about it. There can't be any, nobody can be wavering in the decision. It has to be a unanimous decision if you're going to actually subject someone to hanging or, whatever form of capital punishment.
Mm-hmm. So in our many of us are under the impression, though, Anna, that in any of our jury courts, that the decision has to be delivered unanimously. No.
No. You can have a majority opinion on civil matters. You don't have to have a unanimous decision. If you're going to nullify a law, you need a unanimous decision. If you're going to inflict capital punishment, you have to have a unanimous decision. But if you're just deciding.
a long incarceration, is that considered in terms of capital? Say I was going to put somebody in jail for 20 years. Is that considered
It's not determined by the sentence. It's determined by the nature of the case itself.
Okay.
You know, if it's a murder case, it's a capital case. You know, if the law that is being invoked allows for capital punishment, then whatever the sentence may be, it's a capital case and it requires a unanimous judgment.
Okay. So there's
if you
not
gave life imprisonment, or you gave death by hanging, or you gave a commuted sentence of 20 years, whatever the jury decides is apart from the nature of the case itself. That's what I'm trying to say.
Okay, so if is there any time when that would have to be like a 2/3 majority, or no, just a majority, simple majority?
Yeah, well, and it's like, okay, say that we are considering an issue like a dispute of land ownership. Say that one party has a survey of a parcel of land, and part of that parcel extended on the other side of a creek. And another party has a survey of the same parcel of land that's all on one side of the creek. Okay, it's not a capital punishment issue. It's it's not even a criminal issue. It's a civilian issue of land ownership. Okay, and the person on the other side of the creek is claiming the injury of having this disputed chunk of their property not being included as their property because of this counterclaim. Mm-hmm. Well, then the jury goes in and they're looking at different factors. Who has the prior claim? How did that claim arise? What survey methods were used to make the determination that the land line actually dropped here and made this corner? Is there a mistake in the survey? All these different questions come up. Everybody looks at it, and the jury renders a split decision of 8-4. The issue then would go back to the landowners and determining, whether the landowner is going to accept that, or they're going to, take it to a different kind of court, which they can do. Now, the jury decision is going to stand as an 8-4 decision in favor of, but it's not going to be a final determination. If you had a unanimous jury decision, it would be a determinate decision, and they would have to abide by it.
Plain and simple.
Right. Well, and that's why other courts exist. Right. So that, if you have something where there's that split in jurisdiction and you have a concurrent authority going, in a case like that, you've got two different systems. You've got the land system and you've got the sea system, and the sea system controls the survey. So who's going to decide the survey data?
Right. Exactly. All right. Well, very few questions today, Anna. I guess we did our jobs, and we probably go next week and take a look at our court clerk. That's a big job, and we'll dive into the court clerk. So
what we probably should do is kind of rewrite that list that you had for our justices, because we presented that list, and that's a list of their judges.
That's right.
And, Supreme Court justices. I think maybe we should rewrite that list for us so that people can have something to compare against,
That's really great. I think it's something that's really needed in terms of, clearly defining, because as I always say, whenever we have an issue that comes up, a conflict or anything else, it's usually because there's not something clearly presented or clearly written or communicated that, leaves the holes, right? So, I think that would be extremely helpful to all the states in their jural assemblies to do that.
Okay, well, send it to me and I'll rewrite it for us.
Okay.
And, you're right, Lisa. 9/10 of the arguments that the Federation gets called into to resolve within state assemblies are just absolutely, they're silly. They're silly arguments about whether it's crimson or scarlet or red.
Right. Well, I also, often say, if you don't say it, Anna, or you don't write it, Anna, or otherwise, there are a lot of times no one wants to believe the other research that we bring forward for it. So, I think that's, we at some point we have to begin to discern that and have that in the logical path, right?
Well, and over time, it will begin to click. It will begin to make sense to everybody. And then they'll just know, okay, well, this is our jurisdiction and that's their jurisdiction. And here are the bases in this law and here are the bases in this law. And, they'll be able to come to decisions that are more reasoned, more correct, and more logical.
Right.
Because
and I think we're all still learning so much. I think that's always the challenge. There's so much to unlearn. There's so much to relearn, and research. Sometimes research changes what we've thought was the way it was in the past. And research comes by and says, oh no, there's this, that, and the other thing now, right?
Right. Well, and I compare it to a fence, Lisa. If you're standing on one side of the fence and looking north, you've got a totally different view than if you're standing on the other side of the fence and looking south, don't you?
Yeah, absolutely.
And so, sometimes to get the whole picture, you have to look at both sides, And, the limitation of our court system is that you're only looking in one direction. You're only dealing with one kind of law. And it just so happens that the system of law that we have for people is more just for people.
Right. Okay, well, we are right up on the hour. So I would suggest that we next week be ready for the court clerk. How's that?
I'm not sure I'm ever going to be ready for the court clerk.
Well, I always say the court clerk really runs the court. Just ask him.
Well, certainly that's true in a king's court.
So, all right. Well, Anna, thank you so much for your time. I'm glad that you're feeling so much better. And we did miss you last week, but boy, we took a lot of questions. So it was I think a really productive session. So thank you. Thank you so much. And everyone, we'll see you next week. Be ready with clerk.
Uh-oh.
And court clerk questions. It might be a long one. All right.
Yeah. And do send me that list so I can do up their version, our version.
I will. Thank you. All right, everybody. See you next Tuesday.
Take care, guys.